Welcome to the Labor and Employment Podcast Series. This podcast will address whether an injury suffered by an employee during an off-duty wellness initiative is covered by workers' compensation by Denise Elliott, attorney at law. Ms. Elliott is a member of the Labor and Employment Practice Group at McNees.
Thank you for joining me. This podcast will address a common question I receive as a labor and employment attorney practicing in workers' compensation. Is an injury suffered by an employee during an off-duty wellness initiative covered by workers' compensation? First, what do I mean by off-duty wellness initiatives? Well, here are some examples. Working out in the employer's gym, playing on an employer-sponsored sports team, engaging in activities offered at a company wellness event, starting a cardio program to lose weight and get a discount on health insurance premiums. The answer to the question turns on whether or not the employee is in the course and scope of employment when the injury is sustained. There are two ways that an employee can be in the course and scope of employment. First, where the employee is injured while furthering the employer's business or affairs, regardless of where the injury is sustained. And two, where the employee sustains an injury that is caused by a condition of the employer's premises, provided that the employee was required to be there at the time of the injury. So with the course and scope definition in mind, let's look at some examples to answer the question. So here's an example of an employee who's playing basketball with coworkers over lunch. Let's assume that the company encourages employees to engage in physical activity and promotes the health benefits of physical activity through company emails and on bulletin boards. Let's further assume that the company subsidizes a portion of the employee's gym membership. So assuming these facts, if an employee is injured during the basketball game, chances are the injury will be covered by workers' compensation. In fact, the PA Commonwealth Court addressed similar facts and found that the employee was furthering the interests of his company. He was engaging in camaraderie with coworkers, improving mental health by relieving stress, and improving physical fitness, which could lead to fewer doctor visits and lower insurance costs for the company. So here's another example. Taking a 10-minute walk every day during break. Let's assume you have an employee who takes a 10-minute walk in the neighboring park each day. One day, the employee trips and twists her ankle. Will the ankle injury be work-related? Let's also assume that the company has actively encouraged employees to enjoy the park, to get outside and get fresh air during breaks, and has promoted the benefits of walking. In that case, yes, the injury will be work-related. All right, here's another one. What about using an on-site company gym? Let's assume your company has an on-site gym and employees can use it during non-work hours. Let's also assume that the gym is only open to employees, that the company provides flexible working hours so employees can use the gym before and after work, and that the company has seen a decrease in their insurance premiums. What do you think? If an employee is injured in the gym, will it be covered by workers' compensation? Again, the Pennsylvania Commonwealth Court has addressed this very example, and they said yes. So now, what about employer-sponsored wellness programs? These cases are always fact-specific, but chances are the answer will be yes. In the case of a wellness program, this is especially true where fitness testing and achievement metrics are used to incentivize and reward employees who participate in the program. All right, finally, what about the company's softball game? Getting employees together for physical fitness and fun and to promote employee relations, yep, that furthers the interest of the employer too. The courts have consistently held that the concept of furthering the business or affairs of the employer should be liberally construed. Thus, the key theme with all of these examples is that the employer benefited from the employee's physical activity. So what is an employer to do? Encourage sedentary employees who never have any fun? Certainly not. But there are some steps you can take to reduce the risk of liability. In the case of a wellness program, consider using a third-party vendor. Ask that all communications regarding the program come from the vendor, and do not allow the vendor to share with you any data or statistics regarding the program or participation. If you have an on-site gym or otherwise subsidized gym memberships, limit use to non-working hours only. Don't allow employees to change their working hours to accommodate gym usage. Refrain from sponsoring or encouraging fitness or weight loss challenges, and refrain from actively encouraging or promoting use of the facilities. If you sponsor a softball or other sports team, make it very clear that participation is optional. Open up the team to non-employees if possible, and refrain from promoting the team through company communication channels. At the end of the day, encouraging employee physical activity often has benefits that outweigh the potential risks of liability. And as I said, these cases are decided on the specific facts. So if you have any questions or want to discuss your company's programs and risk of exposure, we're here to help. For more on this topic, please see the information on the following screen.